Good afternoon and welcome back to another edition of Voir Dire, the Crime Talk edition. We're here today to talk about, once again, about the Christopher Watts case, specifically the case up in Weld County, whereby Mr. Watts has previously pled guilty to murdering his wife, who was pregnant, and his two young daughters. Last week, Mr. Watts entered a plea of guilty to all of the counts in exchange for the district attorney not to pursue the death penalty. We talked about that plea in great length, and the video will be linked below if you'd like to watch that. Then we did a video about whether Mr. Chris Watts got punked, and the question was not whether he's some innocent person, whether he deserves to be treated differently than any other defendant. That was simply not the case. I received a lot of comments of somehow whether we were the Christopher Watts fan page. Not the case. We here at CrimeTalk were simply trying to provide some analysis of criminal matters much deeper than what you'd find on your local news snippet, which lasts for about 2 minutes and really doesn't go into the facts. And what we were looking at and exploring was, did Mr. Watts really get a deal at all? And that's what we were talking about, was he pled straight up guilty to every charge in his complaint and information in exchange for the death penalty to be withdrawn. And the question was, did he really get anything in exchange for that? Any attorney could sit there and basically get the same result that he got by pleading guilty by simply showing up. He got no bargain, in my opinion. And the reason is the death penalty, although on the books, is effectively dead here in the state of Colorado. We have a governor that has said he will not impose the death penalty. He is leaving office. The new governor has stated that he is personally opposed to the death penalty. So it would be very unlikely, even if after 20 years of appeals, that Mr. Watts would ever be sentenced to death, even assuming that was the case. Now, I've had lots of clients all along the years, some 24 years of practicing criminal defense work. And if a district attorney came to me with the offer of plead guilty, open sentence, I'd say, prove it. You can go to trial. Prove it, each and every element of that charge, beyond a reasonable doubt, unanimously for a jury of 12. My client's not going to do something unless we're going to get something in exchange for it. So that's what we were looking at and exploring in the Mr. Watts video that we did about whether he got punked, all right? And so that's the issue. That little video created a lot of stir. Mr. Watts' mother has gone on all the local news media channels and stated that she has questions about the plea. This is same questions that basically we were asking here at Crime Talk, is simply, what did his attorneys accomplish in the time from this case began to the time that he entered a plea? I'm not saying they didn't do a good job. I don't know. I'm just surprised at how quickly this case transpired from the beginning to the time of plea. We weren't even at a preliminary hearing yet, okay? I've seen DUI cases take longer to resolve and take more time to be completed than this particular case. And this is a case where literally they were looking at the death penalty. Someone spending the rest of their life in prison. You usually get a little more due process than you do on your run-of-the-mill type of case. And so I'm not saying they did a poor job. I'm just simply saying I'd like to see what they did. And that's what Mr. Watts' mother has been asking on TV. What did they do? We don't know. We'll probably never know unless Mr. Watts tells us what they did or what he believed they did. So in that regard, his mother also questions whether he was able to talk to his family about the plea. On her videos that she has done with the news media around here in Denver and nationally, she questions why she wasn't able to spend more time with her son doing that. And apparently his attorney didn't want Mr. Watts to talk to her about the case. That's not necessarily unusual, but I can't imagine someone going to go into a district attorney is going to bring his mother in to talk about whether he should take this deal or not if the matter ultimately went to trial. I don't see that happening. But ultimately, it's Mr. Watts' decision. He is a big boy. He is a grown man, a married man, a man who had 2 children until they're now deceased. So he's the one making the decision. This is not mom and dad's call. He's a grown man, all right? And so when we talked about when Mr. Watts pled guilty, that the court went through a colloquy, a conversation with Mr. Watts, and we have ordered that transcript. And although we're getting a little bit of pushback from the courts asking why we want it and things of that nature, which is ridiculous because, frankly, I'm asking for it. I can order, anybody should be able to go and order any transcript in any criminal case and receive a copy of it as long as I pay the court reporter her fair fee. There's no reason why it should be denied. But anyway, so the court goes through this conversation with the defendant, in this case, Mr. Watts, to make sure he understands the charges that are against him, what he's pleading guilty to, what his rights are, the rights that he gives up when he pleads guilty, and then the possible penalties. And the judge further goes on in this conversation and inquires, are you under the influence of alcohol or medication? Are you thinking clearly here today? Is this your decision? Is this your free and voluntary decision? Not what anybody else wants you to do, but it's your decision. And the judge will usually tell the defendant, you don't have to plead guilty. You do not have to follow your attorney's advice if they have asked you to plead guilty or say that it's in your best interest. You have an absolute right to make the government prove their case beyond a reasonable doubt. Okay? Bottom line. So then, what the question then becomes is, if Mr. Watts attempts to withdraw his guilty plea, well, he has to do it or attempt to do it, or somebody has to do it before Monday. All right? That's his sentencing. Because after sentencing, it's a different legal standard that's going to be imposed. And his own attorneys more than likely cannot do it because they're going to think we have no factual basis for it. We were not ineffective. We didn't do it. He has to have a new attorney. So between that time now, or when he's retained, the attorney would have to get up to speed, try to get a copy of the transcript. He could ask for a continuance, but the judge is not going to give him a long one. And the judge may say, you know what? I took the plea. I don't see any basis to withdraw it. And so what the court has to consider if someone does make a request to withdraw a guilty plea prior to sentencing is they have to look at it as a fair and just test, all right? And the decision whether to allow the withdrawal of the plea is decided in the court in the exercise of its discretion on a case-by-case basis, all right? The court's ruling on an application for withdrawal of a guilty plea will not be reversed except where there is a clear abuse of discretion. And what that is, that's a fancy word that says unless the judge just completely missed the ball on this one, the appellate courts are not going to reverse him, okay? And obviously it can't be done, the request to withdraw a guilty plea cannot be done with an attempt to delay the proceedings or something along those lines in hoping that, witnesses would disappear or evidence would be gone and things of that nature, all right? And the first thing the courts must consider when analyzing this fair and just standard is first, is there a defense worthy of consideration by a jury, okay? So that's really the big question in this particular case. Mr. Watts apparently told the police that he had, in fact, killed Shanann when he observed her killing his daughters and that he just lost it, all right? Whether that's true or not, I don't know. That's what is in the affidavit for the arrest warrant. So is there a defense as to the death of his children? Yes, there would be, possibly, okay? We don't know what other evidence there is out there. And as to Shanann, yes, he says he killed her, but then the question then becomes, was it after deliberation? Was it second-degree murder, heat of passion? Who knows? Maybe it was criminally negligent manslaughter. Maybe he didn't mean to. He just tried to subdue her. Who knows? But there's lesser included offenses from first-degree murder. Second-degree murder would still carry a penalty of 16 to 48 years, plus a 5-year mandatory period of parole here in Colorado, but it would be less than life without parole, okay? Now, he would still not have much of a defense as it relates to tampering with the evidence because he obviously picked up the bodies and then tried to dispose of them. How could that be explained? Who knows? Maybe just he realized what had taken place and he panicked and figured no one would believe him and that was it, okay? So is there a defense? Is there a theory? Yes. But as to after deliberation, we'll never really know. And a quick example of after deliberation is simply that you did something after you thought about it. How quickly does that take place? Well, a classic example is you fire a gun. You're thinking about pulling the trigger after deliberation. Not much time goes by. Another example, you're driving down the street. As you rapidly approach an intersection, you notice that the light changes to yellow. You, in a matter of a second, split second, decide quickly, as you look in your rearview mirror, is there someone behind me? Can I go safely through the intersection? If I cannot stop safely, do I have enough time to stop? Is the car behind me going to hit me? Is there other traffic coming? And whether you decide to stop or go through that intersection, you have made that decision after deliberation. It's that quick, ladies and gentlemen. So is there an actual defense there? We may never know. The other thing that the court has to consider is that the plea was entered by mistake or the prosecution has not fulfilled its part of the plea bargain. I'm not aware of any mistake that was made by anybody, and I'm not aware of anything that the prosecution was supposed to do that they have not. Third, was the plea entered under a misconception of the nature of the charge? I am sure that Mr. Watt's attorneys have explained to him in great detail what the charges are, what the elements are, what the prosecution would have to prove, and also whether the defendant was misinformed about the consequences of the plea or the plea was entered through a misunderstanding. Now the question is did his attorney say, hey, they're willing to take death off the table, you should consider it, but let's be frank and honest, Colorado hasn't really put anybody to death in a long time. They're not going to do it. And frankly, if you can't convict the Aurora Theater shooter in Arapahoe County, which is a very conservative jurisdiction, you may not be able to do it in Weld County either. So you just never know. The question is, maybe he thought that it was an all but certainty that he would receive the death penalty. Who knows? Then the last thing that the court would have to consider is basically, is there a claim of ineffective assistance of counsel or conflict of interest on the part of the counsel at the time that the plea is entered? One of the things that the court would ask Mr. Watts, or did ask Mr. Watts when he entered this plea, whether he was satisfied with his attorneys. And if he had said no, he was not satisfied, the judge would have stopped the plea immediately and basically asked what was going on, let Mr. Watts think about it, come back maybe the next day, whether that's what he wants to do. And this goes back to why the court engages in this conversation with any defendant, is so that they don't get this buyer's remorse next week, a few days, months, years later, saying that they want to withdraw their guilty plea. That's why they do that. There's nothing to say whether his attorneys were ineffective, and frankly, I'm not going to say that his attorneys were ineffective. The only thing I've ever questioned was how rapidly this case was resolved. We didn't even make it to preliminary hearing. I cannot imagine most experts, if they retained any, would have had their reports reviewed, analyzed, determined how they fit into the bigger scheme of things in such a short amount of time, and whether all the testing that was done by the prosecution through the Colorado Bureau of Investigation had been done. Usually it takes weeks, if not months, to get those lab reports back. So the only question is whether everybody had, for lack of a better term, kind of the complete picture. But understand, nobody forced Mr. Watts to plead guilty. Nobody twisted his arm, okay? And he's a big boy, and just because his mom doesn't like it, the plea, doesn't mean that he's going to get his plea withdrawn. And frankly, it looks like there's been no action on the part of anyone to actually withdraw his guilty plea. So, as it relates to the Christopher Watts case, it looks like the next news and information we're going to have is on the 19th. We'll see if he attempts to withdraw his guilty plea. We'll see if he gets sentenced and is sent on his way to the Colorado Department of Corrections. So, the 19th will be a big day. We will see. I appreciate you tuning in. I understand there are lots of channels out there, and the fact that you choose to come here, we appreciate it. We hope that we provide a little more analysis than you get on most channels or on the evening news, and frankly, that's simply because this is what we do. We will be following other cases over the next weeks, months, years, and hopefully providing some analysis that you all find interesting. So if you like the page, please like it. Leave a comment below. If you have suggestions of cases that we should follow, let us know. And if you subscribe and you want to be notified of new videos, feel free to hit that little button there as well, the little bell. Hit that bell. Additionally, you can also follow us on the podcast at the iTunes channel, so to speak. What do they call it? You can follow it, the Voir dire podcast at iTunes. And for those who haven't listened all the way through before, this is the CrimeTalk edition of voir dire. Voir dire is a French word that means to speak the truth, and that's what our channel hopes to do. We're not taking sides. We're simply trying to provide both sides of the case so that you can decide. Have a great day. Thanks for watching Voir dire CrimeTalk edition, and please leave a comment and you decide what Mr. Watts should do.